Hey, I want to talk to you about how to conduct depositions during the pandemic. So let's say that all of the paper discovery is complete in one of your case, and you're at the phase of the case where you need to do the depositions of the parties. But let's say the defense attorney is not playing along, they're not cooperating, and they refuse, or they tell you that their clients will not agree to use video conferencing for depositions. Here's what we do. We write to the court and we first set forth the law that number one, the defense is not willing to conduct depositions via video conference. Video conference would protect everyone because they could be at their home, they could be at the hospital, wherever they are. You could be at your home. All the attorneys, everyone is safe and everything is videotaped. So there's no interaction at all of people. That's number one. Number two, at least in New York State, the state statute CPLR section 3113 specifically permits videotaped depositions. Rule 202.15 of the Uniform Rules of Trial Courts in New York State also explicitly permits videotaped depositions. And there is a rule in the federal rules, I believe it's section 30B of the Federal Rules of Civil Procedure, that also allows videotape depositions by audio or video remotely. So we've got that. There are federal courts now that are mandating the use of video conferencing for depositions in New York State. Now, I haven't seen anything from a state court, but the Chief Administrative Judge Lawrence Marks has a memorandum that he's issued back in March stating that the attorneys are strongly encouraged to continue progressing with their cases in discovery. So there is statutory and there are rules permitting this. There are regulatory rules in New York State permitting this. And if the defense is allowed to stonewall us and say that they're not going to cooperate with videotape depositions, then the depositions could be off indefinitely because we have no idea how long this pandemic could last. It could last another month, it could last 6 months or a year. And if they're allowed to avoid depositions, then the case is off indefinitely and we can do nothing with it. So what I would encourage you to do is get the law together, write it out to the judge, write a letter to the judge, CC the defense. Even in non-essential matters, the judges and the courts in New York are accepting, as of Monday, written correspondence and email correspondence. No, I should say just email correspondence about discovery issues in the case. So they are encouraged to hold conferences. You should seek a conference and ask the court to direct video conference depositions via Zoom at your expense. You'll arrange everything. It will be easier and it will be quicker and your case will progress. So getting video conference deposition via Zoom is a great way of doing that. Zoom is super easy. We have a special, and it's sort of easy to record as well, but it costs $40 a month for us, unlimited use, unlimited recording to the cloud or to our computer. So it's just really a very safe, efficient way. We also use it for daily huddles of our team operating remotely. So everybody's in touch and we know what we're working on. Okay, so that's my tip for circumventing the obstructionist tactics of defense in discovery, and specifically by using video conference depositions. If you like this video, I would love it if you would leave a comment. Just two words if you like or hate this video. Please subscribe to our YouTube channel, and there is a little bell alarm notification next to the subscription. If you click that, you'll be notified every time we put a new video up, which is every single day. I'll see you tomorrow. Thanks. Bye-bye.